So let's talk a little about pretrial practice, because keep in mind, most cases settle, and so part of your thinking when you're thinking about going to tax court is, well, if we haven't been able to resolve this with the IRS administratively, maybe we go to tax court, put forth some evidence, then we negotiate with an IRS counsel attorney, and maybe we can convince them that, look, there's risks on both sides. Let's settle. Let's not take this to trial. And a lot of times cases will settle during or after discovery. Once all the facts are sort of out in the open, parties realize, well, neither side has as strong of a case as we initially thought, so let's get to a settlement. So the tax court's very interesting. It's one of the few courts where they don't sort of have the more formal rules of discovery initially. They have what's called informal discovery, and this is based on a case called Brannerton, and you have these things called Brannerton requests. And it's basically an informal request that basically the parties will exchange documents and information voluntarily, meaning without subpoenas, without document requests, without depositions. They just agree. You meet and confer with the other party, and you say, okay, IRS, I'd like to know X, Y, and Z from you. And the IRS will say, okay, great, I'd like to know X, Y, and Z from you. And you sort of agree informally to provide each other with documents and discovery. Now, obviously, in some cases, this doesn't go well, and so you have to resort to formal discovery. But generally speaking, most discovery is conducted in the tax court through informal means, which again is one of the big benefits of the tax court. And frankly, the tax court frowns on formal discovery, so if you, at least without exploring informal. So if you, instance, your client goes in there and says, forget informal discovery, I just want to depose IRS agents, I want to start depositions immediately, the tax court is probably not going to enforce a motion to compel that if you haven't tried to do informal discovery. Now, what can you request and what can you get from the IRS, and what can the IRS get from you if you're the taxpayer? Well, you can request any material that is not privileged, so I mean it's not subject to attorney-client privilege or deliberative process privilege or one of the other tax privileges that would apply, and it must be relevant to the case. So it can't be privileged, and it must be relevant. Now, I'll tell you, relevance is an extremely broad concept, and a lot of times taxpayers say, why is the IRS asking for so much? This is not relevant. All my emails related to this business deal, or, all these financials, this isn't relevant. The real issue is, X. And what I'll tell you is it's hard to fight against relevance, especially when it does relate at least somewhat to the tax claim. Because the courts basically say it's relevant if the question may lead to admissible evidence. And that you can just hear it right there. It's a very broad statement. May lead to admissible evidence. It doesn't have to be admissible. Maybe it's things that aren't. And again, you don't know if it will. It just may. So courts tend to interpret that very broadly, and they'll allow parties to request a lot of information. Time, no discovery requests until 30 days after the last responsive pleading has been filed. So you got a petition, answer, reply, 30 days, then you can start discovery. There's tons of different discovery tools. There are interrogatories, production requests, or requests for documents, depositions, administrative summonses, motions to compel to enforce the prior ones that we just talked about. So lots of different tools you can actually use as a party in tax court litigation. So interrogatories are probably exactly what you think of. They are questions. They're interrogatories. You can ask up to 25 of them just automatically without leave of the court. So it's basically 25 questions to your opposing party. Okay. They can only be served on parties, meaning you can ask it of the IRS, and the IRS can ask it of the petitioners, the taxpayers. You can't serve it on like a bank, third-party Bank of America. That they're not used in that manner. However, you can use them on expert witness, and there's no limit. You can do more than 25 to an opposing party's expert witness. If you want to know about, the basis for their valuation or their appraisal report, you can ask questions in the form of interrogatories. Once you serve them on another party, they must be answered within 30 days of service, and you must respond. So if you get a list of questions from the IRS in the form of interrogatories and you're in tax court, you must respond in good faith, or you must object. Okay? These are not filed with the court. This is all done sort of informally between the parties, unless one party doesn't comply, and so the other party files a motion to compel, or most files a motion for sanctions for failing to comply with the discovery request. Or if you're a party that gets what you would say unreasonable or interrogatories that hit on privilege and the other party is demanding you answer them, you can file a protective order with the court to say, hey, court, I'd like you to step in and say that these interrogatories are wrong because they're requesting privileged materials or doing something else that's inappropriate. All right, let's talk about production requests. This is basically just requesting documents. So both parties can ask each other for documents. That's electronic, tangible, all kinds of different things. They can ask to enter real property. So they can ask to inspect the premises of like a business, for example, or a vehicle, for example, if that's an issue in the case. You have 30 days again to respond with documentation or with arranging to enter real property to inspect it. And again, these aren't filed with the court unless someone files for sanctions or a protective order. One thing to note, just a sort of practical tip, if the IRS wants to inspect a proprietary database that has confidential information and they want just turn over the database, a lot of times counsel will be reasonable there, and you can go to them and say, look, we can't just give you our entire proprietary system, but we'll let you come in, we'll walk you through the system, we'll have someone sit you there and let you look at anything you want, but we just can't let you take it off of the premises. Will they always accept that? No, but I've found in most cases they will accept that, where there's a realistic reason why the taxpayer can't just turn over their whole proprietary system. Requests for admissions, these are basically asking a party to say true or not. So, on March 5th, did you issue a statutory notice of deficiency? Yes or no? Parties can serve it on each other to request the admission of the truth of any matter. It's got to relate to statements of fact. So you can't ask the IRS to say, admit or deny that, Section 162 says you can't have losses unless X, Y, Z, right? You can't ask legal questions, but you can ask about factual questions. So admit or deny that the agent issued a report on January 1st, right? That's a legitimate request for admission. The served party, when you get these, you have 30 days to respond to the requested truths. If you don't respond, they're deemed admitted, meaning if you get a bunch of questions, requests for admissions from the IRS, and you just fail to respond, you're in real trouble, because then the truth is admitted. It's as if you answered, yes, that is absolutely true. Okay. Unless there's an objection, such as, again, privilege. But keep in mind, again, relevance is very broad, and if you object to these things based on relevance, just say, well, that's not relevant to my case, so I'm not gonna admit or deny. I'm not gonna respond. Those will generally be deemed admitted. So again, be very careful. You've got to respond to these. Expert witness reports, all right? That's another in valuation cases, in transfer pricing cases, in cases, estate tax cases where you're talking about the value of property. Sometimes you need an expert to come in and opine on what the value of the property should have been. So they have to issue a written report. You send the report to the IRS for most taxpayers. Sometimes courts will appoint expert witnesses, although that's pretty rare. If you are going to have an expert report, again, make sure you've got the right things. You've got to summarize the expert's opinions. You have to have complete statements of the opinions and support for them. They can't just sort of state their opinion. They must actually show their work, so to speak. You got to tell the IRS and the court how much they were paid for their testimony or their report. They've got to show the facts and data, what their underlying assumptions were. They've got to list their qualifications. And they've got to list the previous cases in which they testified. And if you've got expert witnesses, they're not used in most tax cases, but if you do have questions about that, in your case, please feel free to give me a call. It does get a little more complex than this slide would indicate. But again, most cases do not involve experts. All right, so other issues. Again, cases tend to get assigned based on where they're designated in the petition. Unlike most federal courts or all federal courts, there's no pretrial conference. You don't have to have a pretrial meeting with the IRS, although it's advisable to do that with the IRS and the court just to sort of set the schedule and figure out what the judge is looking for in terms of timing and exhibits. But you don't have to have a pretrial conference. A lot of times, if you do have a conference with the judge and the other party, it's just done telephonically in the tax court. You just meet on the phone, and you can talk about logistics, timing for the trial, how many days of trial, and things like that as well. Motions in limine, I won't talk much about this, but basically, those are motions where you can try to exclude certain evidence before trial. So for instance, let's say the other party, the IRS, submits an expert report that you just think is totally bogus. It has no foundation, the person's not qualified, it's just terrible. You can file a motion before trial to say, we don't want them to testify because we don't think they're qualified as an expert. And if you can support it, the court may stop the other party, in this case the IRS, from actually using that expert or that evidence at trial. You can file other pretrial motions, such as motions for summary judgment, motions to dismiss. There's a whole array of them. Again, too much to go into in a general overview, but there's lots of different motions that can be filed if you have special circumstances. I think all judges in the tax court will have something called a pretrial order, meaning something they give to all parties basically saying, hey, here's what we want you to do. Before trial, here's what the deadlines that we want you to meet. And usually what they involve is stipulations. You must stipulate, meaning you and the other party, the IRS and the taxpayer, must agree to everything that can be agreed upon. So you must create a joint statement of facts, essentially saying, we agree that X, Y, and Z happened. You can still disagree about lots of stuff, but to the extent that you can agree, under the tax court rules, you are required to do so, and the judges will enforce that if you don't do it. Judges get very upset if the parties don't stipulate before trial. Okay. Now, the pretrial order is also going to require that you give notice to the court if you have settlement. So you can engage in settlement discussions up until trial, but if you settle, you've got to inform the court of that settlement. And then, as always, a court can at any point during the proceeding dismiss a case for lack of jurisdiction and other issues. So if it turns out the court really doesn't have jurisdiction and that comes to light later on in the proceeding, such as maybe the notice of deficiency was never issued, the court can actually dismiss the entire case, and that can go in favor of the government or the taxpayer, just depending on the particular issue.